another installment of Marshall Law. Marshall Chriswell on the line with us this morning. This radio program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Say a guy like Marshall Chriswell is on the line with us. Good morning, Marshall.
Good morning, Todd.
Good to have you with us here today. We see it all the time. We watch the court shows, and there are always objections raised, and we wonder about them. Well, there are all kinds of issues. So let's talk about objections that are raised in a court case. And I would assume that objections are not only raised in criminal cases like those high-profile things we see on TV, but in any courts, a course of a trial or of a court proceeding. Is that correct?
That's absolutely correct. You see objections are raised in any court proceeding, be it civil, criminal, even at an arbitration, a deposition, really any proceeding where you're eliciting evidence and testimony. The rules of evidence apply, and each state and the federal courts all have their own rules of evidence that you have to abide by. And when those rules are in effect, you can always make objections to the evidence and testimony that's being presented.
All right. That being the case, let's talk about why some objections are upheld and some are denied, and obviously it has to do with interpretation of the law. Correct?
That's right. And so, just generally, as a lawyer, when you're in a court proceeding, it's part of your job to ensure that objectionable evidence and testimony does not enter the record, does not come onto the record. It's your job at least to identify when there's objectionable evidence and then make a determination about whether you're going to object to it coming into the record, because there can be sometimes a witness may be asked a question or answer a question that would be objectionable, but for some reason you may decide not to object. You might decide, well, that actually helps my case and doesn't hurt it, so I'm not going to object. Or it's just not that important of an issue to interrupt the proceeding. So, so you've got to make a determination about whether you're going to object or not. And you talk about the court shows, and you see people stand up and pound on the table and objection, and that's pretty rare. Doesn't really happen or happen that often. The courtroom decorum, makes the courtroom a pretty respectful place. You stand up, you state that you have an objection. You wait for the court to be ready to hear the basis for your objection, and you make that. The other side gets to make an argument as well as to why that objection should not be upheld, and ultimately the judge is going to make a ruling and move on. And you're making objections for a couple of different reasons. One is to ensure the best outcome for your client at that particular proceeding. Okay. Also to uphold the rules of evidence and to ensure that the record is clean. But also, and a good attorney is always looking forward and thinking about what happens if I or the opposing counsel appeal this case, appeal this ultimate decision to a higher court, and that's where objections really come into a heightened sense of importance as to what is in the record that the appellate court gets to see.
I'm sure many people wonder about this because they see it in the court shows again. And that's our point of reference, I guess, for this conversation this morning, is when the judge says to the jury, you'll disregard that, and you're sitting at home thinking, how are they going to disregard it? They just heard it. That has to be very thorny, doesn't it?
It does. You're absolutely right. It is. It's hard once the cat is out of the bag in front of a jury. It's different if you're in a trial where it's just, and most trials are bench trials with just a judge, right? But if you're in a jury trial, and the witness makes this incredible remark, and you object to it, and the judge says yes, the jury shall disregard it, and the jury may be instructed even later during jury instructions, hey, anything that you've heard that an objection has been sustained as to that testimony, you're to completely disregard that in your deliberations. And they may not deliberate about it. They may not talk about it. But still, those kinds of things are certainly going to be playing in the minds of some jurors, depending on how tantalizing that piece of evidence is. And it's dangerous. That's why juries are tricky, because you never know what little thing is going to send them off into a particular frame of thought or decision. And so it's impossible, right, to just pluck that from somebody's mind and say, okay, you're not allowed to think about that anymore.
Yeah, it puts a stain on their deliberations, one would think, anyway.
Yeah, it certainly makes it more difficult, and so it's, attorneys not only make objections during a proceeding, but also there are objections prior to a trial. You can file what are called motions in limine, and other briefs that say, okay, well, Judge, we know that the other side is going to attempt to put this evidence, to put on this witness or elicit this testimony or present these documents, and we want to deal with this preemptively so that it never goes to the jury, so the jury never hears that question and the answer, never sees that document, because we believe it would be improper. So a lot of things can be filtered out prior to, because we go through extensive discovery where we depose witnesses and we do document discovery where you see the exhibits that are going to be presented, but there are always surprises.
Beyond the dramatic theatrics of a criminal case and on to something of a civil nature, I would imagine that every once in a while, or maybe it's more common than every once in a while, in property disputes, that objections can be raised concerning old deeds and old property lines and things of that nature, and in a civil case that would not be all that uncommon.
It's not that uncommon. There are certainly objections raised all the time in civil cases. You think about documents. Now, documents that are of record, deeds and other documents that have been recorded, those are always admissible. Okay, you can always get those in. Now, we can argue about what the language is and why a deed says what it does and whether it conflicts with another deed and those kinds of things. But just as far as getting them into evidence, a government record is generally admissible on its face. You can present it. Nobody really would have an objection to that. But most documents that are presented in a civil or criminal case, most documents are hearsay, right? If I present you, if I'm in a case for that involves property damage, and I present as evidence, I've got the property owner on the witness stand, and I try to enter the bill from the contractor that had to do the work at the property at $10,000 of repairing drywall and plumbing and whatever it is, and I present that and try to get that into evidence. The other side's going to say, "Hey, that's objection. That's hearsay. That's just a statement from this contractor of how much this costs and what the work did. Where's the contractor to testify to that? Because that's hearsay." So basically, any document is a statement, and you've got to have some exception to the hearsay rule to be able to admit it.
Yeah, I would guess as well, and again, I'm just throwing these things out here this morning, that in estate law, when there are wills that are contested, that there can be objections raised there as well. Any civil proceeding like that is you're going to be able to object. Now, one interesting objection sort of related to estate law. There's a rule in Pennsylvania called the dead man's rule. And so if you're in a civil case, and let's say it's a contract dispute, and one of the parties to the contract has died, and the other party is not going to be able to testify about anything, basically anything that the deceased party said
in negotiating and forming this contract and the performance of it. And so they're going to be barred because this person has passed away and they can't speak for themselves. Now, when you talk about estates, there's an exception for that. If someone is challenging a will, and they need to testify as to the mental capacity of the person creating the will, and they need to talk about things that person said or did. That's an exception to that rule. But generally, if someone has passed away, the dead man's rule applies, and you can't testify as to what they said.
Wow. All right. So obviously, what it all points to is the fact that you need an advocate, somebody on your side of any case, right?
You do. I mean, you don't know how many times I've been in court proceedings and the other party maybe hasn't had an attorney or hasn't had an attorney that necessarily identified objections very well, things like that, and just how big of a difference the outcome can be.
Yeah.
Because if one side is able to control what basically what comes into the record and what reaches the judge's ears, then you have a big advantage. So it's important to have a good lawyer.
Yeah, they'll be on their own side.
Yeah.
Right. So if people want that good lawyer and they want that good lawyer to be you, what should they do?
You can always call me, 724-465-5826. We're here in Indiana in the old R&P building, which is 655 Church Street in Indiana, and or you can go online to www.westernpalawyer.com.
Very good. He's Marshall Chriswell. Thank you for the visit today.
Thanks, Todd. Have a great week.
You too.